after they tried to do the plea bargaining and it didn't work out, and it's just brought to trial. This is a chapter that we're going to talk about that covers the trial procedures and pretrial. The public prosecutor in federal cases is the U.S. attorney. Criminal cases are tried by public prosecutors who are employed by the government. These attorneys, they can be termed prosecutors, the district attorneys, they can be county attorneys. I think in Little Rock we have a city attorney. And the Attorney General is the law enforcement officer in the state. And every jurisdiction has a chief prosecutor, and they are appointed, and they can be appointed, but more often they're going to be elected. The prosecution says the chief prosecutors often have numerous assistant prosecutors. These prosecutors act as officers of the law during criminal trials. During pretrial period, the prosecutors have discretion, and this discretion, it's a wide discretion. The prosecutor can decide, okay, there's enough evidence, we're going to go to trial. Or they can say, this case is really, really weak, and, I'm not sure that it's going to be worth anybody's time to pursue it. They can plea bargain, and they can try and do that. The plea bargaining is done behind the scenes. And, I'll tell you one time that it just really, really griped me. It's amazing the conversations they have between attorneys and between attorneys and judges. I had a friend killed in an automobile accident. The woman had been out partying all night, and I won't say she was hungover, but she wasn't completely over the partying that night. And there was the roads were iced, and she lost control of the car, and she hit my friend, and my friend went like 50 feet in the air. And when he landed, I was told that the majority of his bones were broken. He died at the scene. They had, the evidence, the information about her activities the night before. She obviously hit and killed this man. Should have been, at the very least, involuntary manslaughter. Well, I heard the attorney, the defense attorney, bragging that the prosecutor owed him a favor and called it in, and all charges were dropped. See, those are the kind of things that make people not have faith in our system. We're supposed to be pursuing truth and justice through the judicial system, and there seems to be a problem, and the system is not working like it should. And part of it, they say it's overloaded and they have to make these decisions. Part of it is numbers. The prosecutors, they have to have the numbers to show that they're winning their cases. So unless it's pretty well a slam dunk, they don't take it. They'll either plea it out, work out, like they'll have community service or something like that. They work behind the scenes and then get the case off of their books. Like I said, the prosecutors determine whether a suspect is going to be charged, the level of charges, and the amount of charges. Now, when I went through the police training, our particular instructor said, hit them with every charge that you can. Because when you load them up with that many charges, it'll scare them, and the chances are that, they'll try and either plead guilty or that you'll be able to hit them with something that'll stick. Well, when I became an investigator, my partner said, I don't do that. He goes, some people do that, but I don't do that. I make sure that I have one charge, and I make that charge with, all the evidence, and then we go from there. Well, I like the idea of somewhere in the middle. If you've got some good substantial charges, go ahead and put one or two on there, but, hitting them like a scattergun, I think that kind of devalues your work a little bit. The prosecutor is elected. Now, that means he answers to the voters. Again, I've been your prosecutor now for the last 4 years, and we have a 90% conviction rate. Sounds great. But if they only prosecute slam dunks, that may be letting some of the others go, that may be a problem. It's often seen, they're subject to community pressure. Okay. Let's talk about Charles Manson. Okay? Now, when he was arrested, not only was the community incensed, but it went nationwide. And so that prosecutor, he was really, really pressured to put together not only an incredible case, but to charge him with, and make sure that this case was solid and that he'd go to jail. O.J. Simpson. Okay? Now, here we got a problem where you have two communities, and some of them say don't charge him, and some of them say do. So, prosecutor has to make those decisions, and the community can influence those decisions. In Arkansas, very often a lawyer will become a prosecutor. He'll stay there for 4 or 8 years, and then he will try to run for Attorney General. So it's a stepping stone. Then, very often, Attorney Generals will run for either governor or senator or representative, U.S. representative. So the prosecutor's office, it makes decisions. It has, it's responsive to voters, and it can be a stepping stone. People view the prosecutor as a crime fighter. Often seen, they say often seen as a law enforcement agent, but I don't think, personally, I've never thought of them like being a crime fighter. I've seen them as being, the Perry Masons and the ones that came after the crime fighters, but the book says they're often seen as a law enforcement agent. I can tell you that there can be some police and prosecutor conflict. My partner had a child abuse case, and he thought that it was solid. He took it to the prosecutor, and the prosecutor said, "No, I don't think that we can go with child abuse. Let's just knock it down to child endangerment." Well, that didn't sit well with my partner, and I think he said, "Let me see if I can go back and get some more evidence and strengthen the case. But, there's where some of that conflict comes. I know for a fact that there have been cases that it looked like absolute slam dunks. And big murder cases. And the prosecutor pled it out. And that torques police. When they work hard and they get a slam dunk case, and especially one that is a homicide, and then it's pled out, that doesn't strengthen relationships with the prosecutor. Knowing the investigators, I know that they have favorite prosecutors that they work with, and and they know which ones have their particular area that they really like. And so if there's a child abuse case, the cop may go to this particular prosecutor and say, okay, I've got this case, what else would you suggest that I need to, really seal it off? The cases are assigned to the prosecutors, but the police work with all of the prosecutors because they rotate those cases and such. Prosecutor is supposed to be a victim advocate. He's supposed to be one that protects the victim's rights. Does anybody have an idea when when the victim might feel like this was not accomplished? Do what?
A failure to prosecute.
A failure to prosecute a rape. Knocking it down to a lesser charge. Yeah, if we're talking rape, and it was a brutal rape, the victim, if the offender either gets off or they plead it down, and especially if they don't, discuss it with the victim, she feels violated again many times. And so, there are times that I wish the prosecutor was always on the victim's side, but sometimes they overlook that. The defense attorney. The defense attorney's job is to assure the defendant has due process, that all of their rights are protected, and that hopefully they can get them off, but if not, they can get them the best deal they can. The defense attorney provides the legal representation for the defendant. Now, when the defense attorney gets the case, they will probably either have an investigator go out and check out all the evidence, or they, might find out in different ways what the information is. So they'll be investigating the incident. They are the ones that communicate with the prosecutor. They also communicate with the judge. It's amazing what goes on in those judges' chambers. When they communicate with the prosecutor, that's when these plea bargains are really formulated. And they will, okay, you beat this guy up with a baseball bat, and all of his teeth have been knocked out, and yada yada yada. Instead of attempted murder, why don't we just, knock this down to, assault and, endangerment or something like that, They'll make it a smaller charge, and that way they can clear it from the books. The defendant will get some kind of punishment. And it's supposedly a win-win situation for both sides. Now, the prosecutors, they will plead when, first of all, if they see that their case is weak, real weak, they're going to be very anxious for a plea, because a plea there is better than a loss. Sometimes they'll plea because there's an overload in the different, like in different jails or their caseload and such. And so by pleading, they can get this off the books. The defense attorney, after he investigates things and he's researching the different parts of the case, all of this is preparing for the trial. He's going to look at the evidence, he's going to look at any kind of depositions that have been taken, he's going to be talking to the defendant, he's going to be analyzing all this and trying to research different case law that might apply that can either get the defendant off or reduce the charges. Then, when the case opens up for trial, the defense will be giving motions. And he submits these motions such as, Judge, I'd like to suppress this evidence. I believe that this evidence was obtained in violation of such and such a law, such and such, the amendment, things like that. And so that's when they make those motions, and the judge will rule on that. He is the representative for the defendant at the trial. Sometimes after he has, if he's lost and the sentencing phase is coming in, sometimes he can go and negotiate a better sentence by talking to the judge and the prosecutor, telling them, circumstances that exist in the life, and this is his first offense, and he came from this kind of a family and such. And so he'll be an advocate then and try and get the best punishment that, that he can. The judge has a lot of discretion, and he can give a minimum sentence, he can give a maximum sentence. And so there's a lot of leeway there, a lot of wiggle room, and that defense attorney is going to try and get a less sentence on that. After the verdict is in and there's a guilty verdict, that defense attorney is going to take the record of the trial and go through it and see if he can find anything, any rulings by the judge, anything at all that can constitute means for appeal. When they go to appeal, they can only argue law. They don't argue evidence. They can only argue the law on that. The lawyers I know, almost every one of them will say the most commonly asked question is, how can you defend somebody that's guilty? And what's interesting is they always give the exact same answer. So I think they may be programmed in law school to answer that question. And the answer is, everybody deserves due process. Everybody deserves to have their rights preserved and enforced. And so, even if you know they're guilty, they deserve a fair trial. That I could understand. That I can say, that's good. But, there's a difference preserving rights and getting somebody off. And so, I have a little bit of a little bias there, and, I'm not completely comfortable with that. The most important role for the defense attorney is to be an advocate for the client. The public defender is one of the people that will defend a client. They can choose and their own defense attorney if they have the money to do it and go pay for them themselves. But if you do not have the money, then especially like here at Little Rock, they will appoint a public defender. And many times these people are just really, really sharp in criminal law because that's all they do. And so they become really, really experts in criminal law. Let's see here. How is when a person says, I don't have the money for an attorney, I need the court to appoint an attorney, there's three ways this happens. One is that we were just talking and saying we were missing you.
A tree fell on me.
Do what?
A tree fell on me.
Oh my gosh. Ooh, I'm sorry. If they say they want an attorney and can't afford it, one way is for the judge just to pick an attorney and say, okay, I want you to defend them. I'm not sure, but it seems like they're supposed to do something like that as a lawyer, some kind of community service. Another way that attorneys are appointed for as a defense attorney is the state or the county. They will. I'm sorry. We'll wait a second. Okay, the state or the county, the city, they will contract with a law firm, and they will pay that law firm X number of dollars so that they can just go ahead and send somebody over there and say, I need a lawyer, and that way it's set up and the law firm can assign an attorney. And then there's the public defender. Now, when you say you want a lawyer, you are not allowed to pick a lawyer. If you say, I don't have money to buy one or to get one, and the court appoints it, I wanted the bigwig over here, the Matlock or the Perry Mason, and that's who I wanted you to appoint, and it doesn't work that way. The indigent defendant must accept the public defender that is provided by the court system. Conviction rates of defendants with private counsel versus publicly funded attorneys are generally the same. And 3/4 of public defender programs exceed their recommended caseload. And I can see that. All of our all of our, criminal justice systems are just terribly overloaded. Overloaded, underfunded. It starts with the police department, you know. I'm not gonna tell you which county, but, I was associated with a deputy one day that was telling me that for the entire county, they only had 2 deputies, at night to cover everything. And when you know that, you know, it's a large county, that's a little scary. Because, you know, you have both of them tied up, and then another call comes in that's a hot call. You know, they have to get that cleared out before they can come over here. And the people are waiting and they're screaming at the dispatcher and, you know, I called you 20 minutes ago, 30 minutes ago, where's the cop, you know? A lot can happen. And so, cops are underfunded, the cops do not have enough personnel. Then we get into the judicial system and where the trial takes place. Caseloads are just absolutely swamping them. And many of them are understaffed, underpaid, you know, not enough money to pay the decent salaries and such. And then you get into detention, and the prisons are overloaded. And then they have to decide who to let out early. Effectiveness of, let's see here. Okay, we got that. I wear several hats. I not only wear the hat of a law enforcement officer, I'm a licensed therapist, and then I'm also, you know, a teacher. And in all of those, it's imperative that you are able to establish trust with the people that you work with. As a police officer, if a person doesn't trust you, that makes your job tremendously harder. They go into a neighborhood, and that neighborhood doesn't trust the police. It's so hard to solve cases when people won't come forth with information. You know, as a therapist, you have to have trust for the person to open up. It's the same thing when you talk about the police officer or the legal counsel. There has to be a trust relationship between the attorney and the client. You know, I've always heard there's 2 people you never lie to. One is your doctor and the other's your attorney. It's a big no-no to lie to either of them. Attorney-client privilege. The attorney must do the utmost to serve a client, even if the client confesses guilt to the attorney. Defense attorneys may disclose contents of conversations with the client if the information concerns a crime yet to be committed. United States versus Zolan. You know, therapists can't do that. If a person says, I'm going to commit this crime, the only thing that is an exception is that they give the name of a person and, you know, like, I'm going to go and kill this person. Then you're legally bound to break confidentiality, call that person and tell them that their life is in danger. But I literally had a person tell me that they were going to commit a crime, and I called up the board and they said I could not break confidentiality. And I also told them this same person had informed me about a murder that he had committed. And it was an unsolved murder. And the board said, you cannot disclose that information. Confidentiality is really, really big in many professions. One of them is the attorney. And they are supposed to keep just about everything very, very close to their best. Well, a crime is committed, evidence is gathered, a suspect is identified, the case for probable cause is made, so they go out and arrest the person. That person then has to have what's called an initial appearance. Here, the charges are heard, the constitutional rights are explained to the person, and whether or not they are eligible for bail is determined. Sometimes the bail is set very high, sometimes it's set where they can meet it without much problem, and sometimes a person is let on their own, released on their own recognizance. The amount or conditions set by the court intended to ensure that the defendant will appear. So the court is supposed to make it worth their while to come back. And so, you know, if you release Bill Gates, he'd probably have a major bail to have to meet, probably have to give up his passport, and a high bail for him would not be excessive. It would have to be so significant that it would have to be meaningful to him to come back to trial. See, it has to be, bail has to be to the point that it's worthwhile to the person to come back and not lose what they've posted as bail. Bail is provided for under the 8th Amendment, but bail is not guaranteed. Judge can deny bail. It is not guaranteed. If the judge feels like the guy's a flight risk, if the offense was one of severe violence, if the offense was one that maybe the death penalty would be a possible sentence, then that person may not get bail. The judge, again, has discretion, and things that can influence the judge. The risk that the guy's going to skip, overcrowded jails, you know, uncertainty about who this guy is, and you know, do you have all the facts? I'm not really sure that you know, this guy is really as poor as he says he is, or whatever. So, let's see here. Establishing probable cause. The preliminary hearing, then, you have the initial hearing, and then you have a preliminary hearing, and that process begins the discovery of information. The charges are going to be read, the attorneys are going to be starting to be in communication. the defense attorney is entitled to have access to the information and evidence that the prosecution has. You know, you're not going to get a lot of these bombshells dropped in a court like you see on TV. Trials really can be very boring. Discovery is when an attorney is going to ask for the evidence so that he knows what the case is and how to prepare a defense. It says here it's a keystone in the adversary process. The grand jury is mostly federal. When the attorney is starting to want to prepare a case and get an indictment, many times they'll form a grand jury and let the grand jury hear that evidence. They are not the jury that will try them. They are the jury that decides if there's enough evidence to try them. So it's a group of citizens called to decide whether probable cause exists. In other jurisdictions, prosecutors can provide information which replaces police complaint as the formal charge against the defendant. Grand jury hears evidence, or looks at the evidence, hears testimony, and it is provided by the prosecutor, and the rules in a grand jury are entirely different than if they were in a regular trial. I'm not sure all the intricacies of how they're different, but the bottom line is, if the grand jury finds that there's probable cause, then the person is indicted and the charges are going to be filed and they'll go to trial. The prosecutor will receive the information from the police, and it will be presented to him or her, and she's going to look over that case, or he's going to look over that case and decide whether to go forth with the case. Now, that decision, it can be based on several things. One thing, scarce resources. How busy are the police that they can help with more investigation? Being overloaded. Other things, like, I don't know if you all know, but the crime lab is so backed up right now that I think that if you have a rush on it, just a really this is an emergency type rush, that they can get your DNA results back in 6 months. I mean, it's just terribly overloaded. And so they have to look at the resources they have, and if there's enough resources to help them. They want to look and see, is there enough evidence to proceed? Is it a weak case or not? How serious is the offense? Oh, this isn't worth my time, this isn't worth putting it on the docket, this is just gonna piss off the judge if I bring this to trial. how cooperative is the victim? I don't want you to prosecute. I don't want this, I'll handle it. My friends will handle it. We'll take care of it, you just back off. Or, how about victims? I can't tell you, because if I do, there's gonna be retaliation like you wouldn't believe. And so, yeah, I'm scared. Don't ask me again. A defendant who is willing to testify against other offenders. They use that a lot. They have a case, and they have a pretty good case, and they'll say, look, you're facing the death penalty. This was a horrendous crime that you committed. Now, we'll knock that down to life in prison without parole if you'll give up your partner. If you'll agree to testify against your partner, we'll make sure that you don't get the death penalty. You get life in prison. They will, that's part of that plea bargaining setup, but they will also use that to turn and flip them against other offenders and to get information. They'll make these deals to get information about bigger fish. We talked about pretrial motions a few minutes ago. Here's some of them. A motion to suppress evidence. A change of venue. A motion to throw out anything that was associated with an poor search warrant or an invalid, a non-valid search warrant. They want to invalidate that. Dismiss the case because of the delay in bringing it to trial. Motion to obtain evidence prosecution may be withholding. They think that the prosecution has more, and they go to the judge and say, Judge, we've got all this indications that they're not being forthright with us.
Would that result in the case being thrown out?
Depends on what the evidence was and what, they're supposed to turn over, the evidence and like testimonies and such, which is bad, because if they turn over a deposition, and this person is powerful, they could either intimidate the witness or have the witness intimidated, trying to get them not to testify. And now there's an example. Judge, we have this witness, and they're not bringing us all the information about this witness, and that is just not right. We want access to this witness, and they're not giving it to us. We need to know where that witness is, and we need, access to them and such. And that would be a motion to obtain something that they think the prosecution is withholding. We've been talking a lot about plea bargaining. After the deal is agreed upon by the defense and the prosecution, they have to take it to the judge, and the judge has to sign off on it. Now, most of the time this happens, but the judge does have the option to say no. The judge has the option of saying, you know something, I don't like the way this is set up. I think that, this and this should be upped, or, I'm throwing this out, go back and try again. Prosecutors, they like plea bargaining, it clears their their caseload. It gives them a positive clearance rate. And they don't have to utilize all, their resources in these smaller cases that they can be using for the larger cases. Conviction removes the risk of jury or judge disagreeing with the case. It saves a questionable case, and it reduces resources spent on the case. That saves a questionable case. A lot of times, the prosecutor will go, oh, we're at the end of the thing, aren't we? One more minute. They'll go to the defense attorney, and they're holding their cards close to their chest. And they're not going to let that attorney know that they're really worried that this is such a weak case, it's not going to make. And so they'll go to the defense and they'll say, look, we'll give you this and this and this if you'll accept this. And, I'm not sure about that. And they'll counter, but it can save a case if they can reach a plea. And so, we'll talk some more about this on Monday. I want you all to make sure you have finished everything in Unit 1. I'm gonna close that thing out. Make sure everything is cleared by Unit 1, on Unit 1 by Monday. Okay? Unit 2, it should be just about done because we finished Unit 2 over a week ago. I'll give you a little more time on that, but be wrapping it up because we're getting awfully close to almost being done with Unit 3. So, be closing out 1 and 2, and that's your assignment for Friday. And, because I gotta give you an assignment to keep this thing rolling so that we don't have to come to class on Friday. So, make sure you work on Unit 1 and closing out 1 and 2 on Friday, okay? You all have a fabulous weekend. Enjoy yourself, be safe. Keep it legal.
Where is this unit 1?